Okay, here we go. Part 5. Based on my training experience, digital devices, okay. Download to detect views of the internet. They want all the address history. They want to seize the computers and go through all this stuff, which will take another year of thousands of man hours because somebody's selling a gun that they knew he was selling and they allowed him to do it under their license. Digital evidence contained also has been detected, blah, blah. 12. Has used herein this term digital device includes any electronic system device capable of storing or processing. Yeah. So if you define this, you protect yourself by not, I wouldn't have done it in like a footnote. I would just put it in the body of the warrant. This guy really seems to like his footnotes. There's probably a 12 footnote in here that I'm not even seeing. Is there a little 12 in here somewhere to say that there's a footnote? Oh, there it is right there, a little 12. So I didn't see that when I first read it. Pretty sneaky. Why couldn't this just be a paragraph? Well, Rick, that's not professional in the right. And as a lawyer, and when I went to law school, they taught us. All right, whatever, dude. Freaking secret, stupid, special, stupid.
Attestation.
Colloquially.
All right, here we go. Programs, application materials, device. Okay, is defining the absence of data and digitally devices. For example, showing the absence of certain software and device may necessarily rebuke the claim that the device was being controlled remotely. Damn, they're trying to go for remote shit too. What do you think? This guy's got a remote digital access in the building next door to hide his stuff that he's doing on the internet where they know it's being tracked, that he's sending through the mail that he knows being tracked, that he's shipping through a shipping company that knows being tracked. Somehow he wants to have a secret squirrel data storage offline. Really? Okay. Digital devices, request for early morning service. Why? As discussed, based on my evaluation, it appears Palmer 80 employees arrived at the subject premises early hours of 5 a.m. Okay, this is a reasonable reason to do this. At 5 to 6. Therefore, I request to execute a search warrant between 5 and 6 a.m. It's necessary by the arrival of these individuals that subject during that time. Once the individual arrives at the subject premises and sees the ATF agents preparing to execute a search warrant, there's a possibility of destruction of evidence and a search warrant. Okay, so this is kind of, I mean, it's legit, but it's kind of BS. So the purpose of doing search warrants must be served like between 6 a.m. and 10 a.m. And the reason why the courts have said that is because it's less likely that a person will think you're breaking in or a burglar if you come during normal business hours. So they've kind of designated 6 to 10 for the time to do a warrant. Some states will do 5:30 to 10:30 or 11:30, but it's usually around 6 to 10 or 6 to 10:30, something like that. You have to check your local state penal code, or if the feds use a different one, I don't know what the feds say. So if you want to do a warrant before then, and a lot of times when we did warrants, if we didn't request special service, we would have to wait at the door. And we would go to the door and we would be in position at 5:55 and I would wait. And then I would get on the radio and I'd go, dispatch time hack or time check. And they would go, it's 5:59. I'd be 10-4. And I'd wait and I'd do it again. A minute later, dispatch, time check. Time 6 a.m. Copy. Please show us out this address, serving a warrant this time. We're doing our knock notice. Now it's on recording that we're doing our knock notice and we're complying with the 6 to 10 schedule. If we kick a door at 5:45 and we weren't supposed to serve it till 6 and somebody gets killed, or we find a dead body, or we find a lot of evidence that of a lot more bigger crimes, trafficking, counterfeit, whatever, we can't use any of that, and we take a chance of losing it because we did a warrant unlawfully and served it too early. So he's requesting an early warrant because they show up at 5. I'm not sure if that's a big deal. Look, if you don't want to serve the warrant till 6, then you lock down the place before anybody shows up. And you go, nobody's allowed to go inside. And then we'll go in at 6. But when you put in here that we got to go in at 6 because they show up to work and there's a possibility of evidence and there's this big exigency and we must do it. And that way we can bang the door, we can kick the door, we can grab people, we can put them at gunpoint, all in the name of preventing destruction of evidence. When in fact, go there the day when they're not working. Go on a Saturday. Serve the warrant on a Saturday. Wait till they're all there and then walk in and surprise them. What is the purpose of this? Because you want to get there before they get there and do the warrant? Or is it you want to catch them when they're going in? Or do you want to really prevent destruction? Because this is kind of BS. And defense attorneys don't question this much because it's become standard, ordinary language, and cops just copy and paste it and put it in every freaking warrant. Every warrant you do, there's always some exigency. Oh, they might have guns. Oh, they might destroy drugs. Or there's kids in danger. Or the kids aren't in school. Or they leave for school early. They leave for school late. Or I want to do it before they wake up. Or I want to throw a flashbang in because I think they have a BB gun. Or they might throw flour in my face and I'm allergic to sugar. And if they hit me in the head with a donut, it'll give me a reaction. I mean, whatever you want as a freaking exigency, you can slide it in there. And attorneys just don't question warrants. And to me, if there's one weakness in the checks and balances of our system, is cops know when I get a warrant, I am golden. Nobody checks it. None of them get thrown out. I can say and do whatever I want in any warrant, and nobody ever challenges it. That's a problem. Defense attorneys ought to be doing cases and doing classes on how to challenge search warrants. And I'll be happy to donate some time to teach one of those. But let's see. Possibility of obstruction of evidence. In addition, concerns regarding preservation of evidence. Yeah, it's always that. I also request authority to execute a search warrant upon arrival of individuals to the subject premises due to operational safety concerns. The search warrant may be more safely be executed when fewer individuals are at the subject premises rather than waiting until more individuals who would need to be secured by law enforcement arrive. Lastly, like I said, why don't you just lock down the building and not let anybody in? Then all these concerns don't matter. Nobody goes in because that's not what they want. They want people to go in. They want to storm the door. They want to force entry when somebody's in there. They want to slam everybody down. They're not doing this to help people. Come on, people. Arrive. Lastly, early execution of search warrant will help to avoid unnecessary disruption to the business operations. Are you freaking kidding me? I can't believe you're lying. If I was a defense attorney, I would absolutely bust their ass in court over this. Really, Mr. ATF Special Secret Super Special Lawyer Agent, you really want me to believe that you want to avoid unnecessary disruption of a business and you just did a warrant to where you're seizing every computer, every device, every cash register record, all their records. You're probably seizing their FFL so they can't do freaking license anyway. You're going to arrest them when you do the warrant so they can't run a business. And you with a straight face and your lies in the search warrant wants the court and the jury to believe that you were really concerned about disrupting their business operations. Are you freaking kidding me? This is probably the biggest freaking lie I've ever written or read in a search warrant. I can't believe this guy wrote this in his freaking warrant. What a lying, manipulative, bullshit, sleazy, low-down, special, super secret, special lawyer agent he is. This search warrant will help to avoid unnecessary disruption of business operations doing regular business. Are you serious? And a DA didn't call him out on this, and a judge didn't call him out on that. I would move this as grounds that the DA that approved this, or the U.S. State's Attorney, or the U.S. Attorney that approved this, and the judge that signed it were both incompetent and didn't read the warrant. No reasonable person would think that this agent is any way, shape, or form worried about disrupting this business operation. And to be honest, I wouldn't. I'd be like, I don't give a shit about his business. He's committing a crime. I want to arrest him. I don't give a shit about his. I would just say it. I wouldn't flat out lie and say I'm worried about disrupting his business. That makes this guy a liar, and his credibility is shit in my book, and I would destroy him on the stand in front of the jury with this warrant. I respectfully request and authorize execute this warrant between 5 a.m. and 6 a.m. in the event that an individual arrives at the premise during that time. It's for them. We don't want to interrupt their business. We want to do this and kick in their door and seize everything in there, including all their products, all their guns, all their records, everything they can do. And we want to arrest them and take them to jail. But remember, we really don't want to disrupt their business. Really? Really? I mean, come on, people. Am I the only one that sees the shallowness of that statement and the flat out lie and misrepresentation? If this was in a contract, this would be a material misrepresentation of the facts and it would void the contract.
This should void the freaking warrant right here. And any judge or DA with any sense whatsoever that read this warrant would have looked at this cop in the face and said, really? You really want me to believe you're worried about this business operation? Aren't you going to shut them down? Well, yeah. Aren't you going to arrest them? Yeah. Aren't you going to take all their guns? Yeah. Aren't you going to pull their FFL? Yeah. And you want me to believe you're worried about their business operations? Yeah. Okay, you're a fucking idiot. And I guess I am too for approving this. And the judge that signed it, you're a fucking idiot too. Jesus Christ.
It is respectfully requested that the court issue a order sealing until the execution of the warrant. So the reason why we seal a warrant is we don't want this warrant leaking out. And what happens when you get a warrant, you have to take it to the filing clerk, and she has to make a copy, and then has to go to this clerk, then have to go to court. So by the time a cop serves a warrant, there's probably 20 people that know about the warrant. Well, you don't want one of them doing it. I tell one of my crazy cop stories where the DA called his girlfriend and told him that we were doing a warrant. And when we showed up, she's like, oh yeah, my DA told me that y'all were coming. We were expecting you. Guess what? We didn't find any image. Well, but anyway, that was a different case. But that's why when you get a sealing order, the court says anybody who has knowledge of this thing, if you talk about it, you're violating the order and you're going to be held in contempt. Not that really anybody gives a shit. If you violate it, they don't do anything anyway. They go, you're a bad boy. You shouldn't do it. Next time I'll throw you in jail. Next time, maybe the DA will file charges that you compromised the case. They're not going to waste time putting that in front of a juror. But anyway, because you're going to cry and go, I didn't know. I just said it to my boyfriend. It was an accident. It slipped out. And you're not going to be able to prove intent. But whatever. I digress. Let's get back to the sealing order. I respectfully request the order seal this until the execution of warrant, which means nobody can talk about it until we execute it. All papers submitted in support of this application, including the application search warrant affidavit, I believe sealing is necessary because the items and information seized is relevant to an ongoing investigation into criminal conduct involving multiple individual entities, both currently known and unknown, and many known and unknown. That would be all you pesky citizens that we now have information that you bought a Palomar. So now we're going to run all your criminal histories and make sure you can possess a weapon. And if you can't, well, you're going to be one of these unknown people that we're going to be hitting up next. So this will be able to justify probably 40 more agents because this is a never-ending cycle of government keeping you safe. Many of the targets investigated remain unaware they're being investigated. Disclosure search warrant affidavit at the time prior to the explosion is serious jeopardize the investigation. Okay, officer safety is going to come in here somewhere. Here we go. Would seriously jeopardize the investigation, and such disclosure may provide an opportunity to destroy evidence and change the patterns of behavior and allow flight from prosecution and premature disclosure of contents affidavit related to the significant and negative impacts of continuing investigation and severely jeopardizes its effectiveness. Therefore, I request and I plead with the court to please seal my warrant. Application search warrant affidavit and all the papers there on to search warrant, at which time documents will be unsealed. Conclusion. Based on the foregoing, I request that the court issue the requested warrant. Let's see. Based on the foregoing, I request that the court issue the requested warrant. Well, I request the court signed the requested warrant that I requested on the requested warrant so you can sign. Alrighty. A lot of double talk here. All right, now here's all the exhibits. Here's the law offices, the reference to your correspondence. This is probably the letter they did that they're trying to say, or this is how the information, Chief Firearms Technology Industry Service Branches. Jesus Christ, man. Chief Firearms Technology Industry Service Branch. Michael Curtis. We thank you. Wow. More government. Okay, we got pictures. I'm going to click through this a little quicker here because I'd like to make this the last one. We got pictures here. We got pictures here. We got pictures here. What is it? Davis Law Firm. Davis Associates. Earl Griffin. Bureau of Alcohol, Tobacco, and Fun. So this is the attorney sent him something. We have enclosed polymer 80 intent to factor. So before you manufacture this, you got to get approval from the ATF. So ATF approved this before they ever did it. We enclosed. But now they're trying to say, oh, well, we approved it, but you didn't tell us you were going to give them a magazine and a trigger and other stuff with it. Well, what does that matter? You're not approving the other stuff. You're only approving the freaking thing. This really seems like a weak case. Maybe I'm not that familiar and I went through it quick. Term firearm means weapon. Okay, this is where the ATF has their standard defined 14,000 things that nobody can freaking understand. And then we'll say, you didn't read it clearly. Magazine catch. Yeah, everybody's getting all this? Because this is about how you need to learn how to... Exhibit 2. the law offices. In reference to your correspondence, disclose a magazine, well, blah, blah. As part of your correspondence, design features process. I wonder if anywhere in here do they say you cannot attach other things with this or sell them together because it would violate. If the letter said that, then I might be okay with them going after it. For your reference, the matter of Bennett, the firearms that include, firearm frame, receiver, foreign casting, machine body, blah, 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 During the examination, FTS personnel found the following machine operations design features present or completed. Front and rear pivot, blah, 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 okay, this is what we say. Machining operations design features not yet present. Here's what you need to do, the other 20%. As part of the evaluation, FDA noted that the following markings, left side, blah, 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 determined that the AR-10 receiver blank could have been machine operation, the rear takedown pin, okay. To reiterate the conclusions of the STIVS evaluation, not law, our branch has determined that submittal of Primary 18 incorporated AR-10 blank receiver incorporating fundamental features is not classified as a frame or receiver of a weapon designed to expel a projectile. So in their letter, they flat out said, we don't think it's a firearm. Now they're saying it is a firearm because you shipped it with a magazine. Are you freaking kidding me? It doesn't change what they built and what they got approval of because of what they shipped. What happens if they ship with UPS and they do a group shipment and they put it in with a bunch of other bags? And now we have parts from several different guns and several different magazines. Let's say they ship the, and this is obviously the defense attorney, hang on, I got to drink some coffee out. My throat's. Let's say they're saying because they shipped it as a kit together, that's where the violation is. So the defense attorney should say, so let me get this straight, Mr. Special Secret Supervisor, Agent so-and-so. If I ship this frame that you guys approved per the FFL, and I'm authorized to ship this, and it's not sterilized, and I'm legal, and you told me I was legal, if I ship it by myself, I'm committing no crime. Is that correct? Well, it depends if you send it to a state, and if you send it out. No, that's what I'm asking. I'm asking, is this, has designed, that was approved by you, can I ship this, let's say, to my state, to an authorized person to do it? Can I sip this gun? Am I breaking any laws? No. Okay, if I send this same gun to another person and I include a magazine, can I do that? Well, it would depend. Okay, let's go with your warrant. If I ship it with a trigger, a magazine, and the pins, can I ship it that way? Well, if you ship it to the state, maybe. Or no, it would be illegal. Why would it be illegal? Because we only approve the handguard itself or the frame itself. Okay, so if I put them together, then it's wrong, right? Correct. Okay, can I send the frame in one envelope and in another envelope, can I send the other items? That way they're not together. Is that legal? Oh yeah, that would be legal. Okay, and if I ship them at the same time and the postman puts them together in his box and now they're together, is that illegal? No. And when he ships it and they're together in the same truck, is that illegal? No. And when a guy receives it at the same time, is that illegal? No. Okay, so none of that's illegal, but if my client puts them in the same envelope, suddenly my client needs to go to prison. Is that what you're telling me? Yes. You sound like a freaking idiot. I mean, how can somebody sitting on a jury not go, you motherfuckers have lost your mind? That's just stupid shit. Anyway, please be aware, while classifying firearms, submittal items classified has defense articles that define the regulation DD 214.7441 CRF 27 regulates exports. Remember, ignorance of the law is no excuse. You should know all these. The U.S. State Department, particular imports, has firearm parts, accessories, firearms are grouped. Defense articles of the USDS oversee direct defense trade controls, information regard. Man, I'm glad that paragraph was in there because shit, I was confused before that. Now I know what the hell I'm talking about. In conclusion, corresponds from the branch of dependent facts, design, characteristics, scenarios presented. Please be aware that although the cases of Missouri branch may appear to be identical, the correspondence pertains. So that's their statement that they're trying to say, hey, you can't say just because we approved it for someone else that we approved it for you. Even if we say the same thing on the same census, you know what? It doesn't matter. It all depends on what we believe at the time that we file charges. And if we want to come after you, well, we can. Even though we told someone else the exact same thing and they're doing it. But if we want to come after you, we can. Because why? Because we're the federal government. We're here to help you and serve and protect you. We caution applying this guidance, and this corresponds to other cases because of complex legal and technical issues may exist. No shit. Differing this scenario, finding also be determined. It is relevant for the item submitted, design, dimensions, configurations, method of operation, changing alternative FBS. It design dimensions and configuring method of operation, utilizing materials and processes such as changing from additive manufacture to injected molding. See, we're still talking about changing the frame that they reviewed. This classification would be subject to review and require. Says nothing about if you ship it with a magazine or if you add parts in the same package that somehow it's illegal. We thank you for your inquiry. Okay, let's go move down here. More pictures. That looks like an AR-10 blank. Lots of pictures. Oh, Exhibit 3. What do we got here? Department of Bureaus. Okay, what page am I on? I am on 92, and it's 119. So I'm going to finish this in 10 minutes because we're at 20 minutes. So I'm going to get through this shit. The Law Offices of Davis. In reference to correspondence, in your letter, you asked for classification of Glock type video on behalf of your client, Plumber 80. If you wish, let's see, this is a lawyer talking to a lawyer. So a business can't ask for something in writing. You have to have your lawyer write their lawyer. Their lawyer has to review it, send it back to your lawyer. Your lawyer has to read it, which is all billable hours, which all costs you money and time and effort on top of paying taxes when you produce it, on top of paying for your FFL license to the federal government, on top of collecting taxes when you sell your items. This is what the federal government wants everybody to do. You can't do shit without coming to us, and we don't make it easy, and there is no right and wrong answer. We get to change the rules and make the rules as we go. And if you don't like it, we'll put you in prison. Ladies and gentlemen of the jury, don't you wish the government could be serving you like they're serving my client? In reference to the matter, you included a weapon which is designated readily convertible to expel a projectile in the action and dispose of frame and receiver of any such weapons. Also in 25, the firearm saying the part of the firearm provides housing hammer. The part of the firearm which provides the housing for the hammer, bolt, and breech block and firing mechanism, usually threaded, is forward position to receive the barrel. Also defines a handgun. In addition, it sounds like a lawyer just trying to get in more billable hours. Handguns, one handgun angle to extend below the during examination of church. What the fuck? Yeah, hire more lawyers to do this shit so you can try to operate a legal business so the ATF can give you a license telling you you're legal and then turn around and run undercover operations and try to put you out of business. But they're concerned about disrupting your business, so they want to serve the warrant early. Oh, yeah, man, this guy's got great credibility. Let's see here. More pictures. What's this warrant? More lawyer. Bureau of Jim Davis. Eval 3802. Dates. All right, this has just gotten way too complex. I think it's going to be overwhelming for a jury to... I mean, this is just a search warrant. If the search warrant is this big, you have no idea what the freaking actual report's going to be when they get witnesses, video, what this agent said, did, who gave what statements, who they call, who they contact. This report and prosecution is going to be massive. And jurors are going to be so overwhelmed with so much bullshit, they're probably just going to vote guilty, when in fact, anytime as a juror you're ever confused, your default should be not guilty. If the government can't convince you and make it easy for you, your default is not guilty. The government failed to prove their case. The government failed to give the pesky citizen a fair trial and a fair chance of succeeding. Your default should always be, government, you lose at every place I'm confused. So if you can't make it clear to me, and when I say clear to me, I'm talking about dumb it down to the 10th grade level so there ain't no ifs, ands, buts, or coconuts, then I'm voting not freaking guilty. How about that? That's what needs to happen on jurors, and then these freaking attorneys and federals will stop doing all this bullshit minutia trying to get stupid shit for everybody. All right? That's the end of the search warrant. All right, so this is part 5. This is the search warrant. I know it went long, a lot of 30 minutes. Hopefully you got some things out of it. You understand the mind of the agents. You should understand how lawyers should be fighting this, what prosecutors should be looking for, what cops should be putting in, why. When you write a warrant, when you write a report, you need to write it as if I'm going to review it later and crack on you.
So it needs to be clear, concise. It needs to be professional. It needs to be in language that everybody can readily understand, that we don't have to look up words. And it needs to be as simple as possible so it makes it clear to the average person. Because you're writing this for lawyers and you think you're trying to impress the DA and the judge. And when he gets in front of a jury of your peers, you're going to look like a freaking idiot, like you're talking down to them. You're going to have to explain everything and you're going to lose them. But in reality, I think government likes to confuse and get jurors to where they feel stupid, because then they're more likely to just listen to the judge and say, you must find, according to this jury instruction, you must find this person guilty if, then they're clear. Blah, 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 blah. That's the only point they're clear. They're only clear in the area that you must find guilty if. They're not clear anywhere else in their prosecution to where the pesky citizen has a fighting chance to even try and do the right thing. And they're getting railroaded and sent to prison and having their livelihood taken away because they went to the FFL and the federal government and tried to conduct a legal business.
Attestation. Attestation.
Colloquially. Colloquially.
All right, we'll end that there.